Welcome to Bankruptcy Through the Looking Glass with Barry Levine. I'm Sam Henniger, and here I am with Barry again. Excited to talk to you, Barry. Let's get started with understanding what, legally speaking, bankruptcy is for individuals and businesses.
What bankruptcy does is enables individuals or businesses to address their liabilities, either discharge them and get a fresh start, theoretically, like the bankruptcy code says, mostly for individuals, or for corporations. I don't recommend, most of the corporations I've dealt with over the decades have been closely held corporations. And I don't recommend filing bankruptcies for closely held corporations for the simple reason that very often, from a Chapter 7 trustee's point of view, the financial affairs of a closely held corporation and the principles of the closely held corporation are sometimes one and the same. And secondly, when corporations, the real reason individuals file bankruptcy and shouldn't do any of these debt settlement and all this other stupidity that's out there is because they get a discharge. They discharge their dischargeable debts. Generally, most of your unsecured debts would be dischargeable. Personal income tax under circumstances can be discharged. What's not absolutely not from a tax point of view dischargeable is unpaid trust fund taxes. As I said before, if you don't pay employee withholding or sales tax or meals tax as the principal, the president of the company, you're personally liable for that. And that does not go away. The other things that don't necessarily go away are student loans. I mean, people have heard about that. There's been up until actually the last year, when people asked me about student loans, I told them that they either had to walk in front of a bus or die some other way to discharge them. It was impossible. Up until I think it was 96 and 97, you could discharge student loans without going through a need and all this other mishigas that they require you to do. But in the last year, there's been a bit of a thawing out with respect to student loans, is that the government, not necessarily allowing the discharge of them, but they're looking more at how long people have been paying the loans, have been trying to deal with paying the loans. And the first one, I have one right now, is that what's supposed to happen is you submit the complaint, which is you always had to do, and then an affidavit from the debtor. And the U.S. is supposed to come back with some sort of offer saying, well, we'll reduce the payments or we'll do this. Like I said, I haven't seen it yet, but that's what's been going on with that. And the only other, debts that wouldn't be dischargeable, and to a certain extent, it depends on what you do with them, are things like mortgages and car loans or car leases. I don't know if you know what happens if you don't pay your mortgage. Generally, they eventually get around to foreclosing, and in Massachusetts, that could take several years. But lots of people out there file bankruptcies to stop a foreclosure, be it a Chapter 7 or a Chapter 13. The automatic stay stops the foreclosure. And if you go through a Chapter 7 when you get your discharge, so going back to my hypothetical, you don't make the mortgage payments, they foreclose on your house, you owe $500,000, the house at the auction brings in $350,000, you're on the hook for that deficiency, the difference between what you owe and what the house brought in. When you go through a bankruptcy and get your discharge, you discharge that hypothetical deficiency. So you could walk away if you did nothing from that mortgage at some point and just say, hey, come get it, I don't really care, and have no consequence. But there's a process, it's called the reaffirmation of a debt. What that does is the debtor agrees that the debt will survive his or her discharge. So my scenario of walking away from it doesn't work. You'd still be on the hook. And the alternative is called pay and retain. You just keep paying. They don't want your car. They don't really want your house because they'll take the loss.
In our previous episode, we had mentioned different types of bankruptcy, and people may be familiar with terms like Chapter 7 or Chapter 13 bankruptcy, but could you really lay that out for us in terms of who's eligible, what the process is,
Well,
and
pretty much, for individuals, most people are, it's a choice between a Chapter 7 and a Chapter 13. And that's really guided by two things, especially as it relates to a 13. A 7 is strictly income driven, based upon what your household's income is. If you're under the median, you file a Chapter 7, nobody questions you. Basically, from filing the case to getting you discharged takes 4 months. The Chapter 13 is driven by two things. One, income, because I've had a number, as I mentioned in the last episode, a number of clients who make a lot of money. I wish I made that much money. They have to file because they're above the mean, and then the means test will tell us how much they have to devote to their unsecured creditors. The other thing that drives Chapter 13s is, and it's starting to pick up again because during COVID there were no foreclosures for the most part, but now if you haven't made your mortgage payment for 2 years, you can file a Chapter 13. And as long as you could, this of course is, my father said if he had wheels, he'd be a baby carriage, or easier said than done. You can pay the arrears out over 5 years, but you also have to make all your current expenses, such as your mortgage payments and everything that goes along with it. And you'd be amazed at how quickly 5 years passes. Some individuals, because they're, and offhand, I don't know the statutory limit for a Chapter 13, have to file a Chapter 11. And basically in the Chapter 11, because Chapter 13s for individuals or people who are DBAs, they're like baby Chapter 11s. You're involved with the same thing. The scenario is the same. Getting back to the corporations and why I don't recommend them, I can give you a good for instance. When I just opened up my office, I needed some office equipment. And I was still a member of this barter exchange. And they sent me to some company that when I walked in to order office equipment, they were doing business like gangbusters. And this, of course, is 1980, before computers. And I found out later that they wound up owing the taxing authorities a lot of money. And instead of filing a Chapter 11 for their company, they filed a Chapter 7. So the company was liquidated. And because they had a creative accountant who, when they set up the company, said, you've lent money to the company, why take income out? Why not take loan repayments? And the attorney who did their bankruptcy petition, I don't know, a preferential payment in a bankruptcy, what was it, in the Madoff case with all the clawback bullshit, whatever they call them, when a creditor gets more than they would be entitled to within 90 days prior to the filing, or as it relates to insiders like these two individuals, it's a year, the trustee can get that money back as a preference. So this couple, by that time, they got me involved. And I went to the 341 meeting, and I happen to have known the trustee is no longer with us, a guy by the name of Ben Tesler. And he turns to me and he says, Barry, so tell me, your clients have $96,000 to pay the estate? I said, Ben, what are you talking about? Every preferential payment was listed there. So the next thing they knew, they had to file a Chapter 13 themselves. But there sometimes is poetic justice. Several years later, after they tried to pay off the Mass Department of Revenue and found out after making payments for a year that they owed more money a year later than they owed the year before, they then received a refund from the IRS of $48,000. And it was wrong. They had no business to it. And it turns out if you keep it for a year and they don't reclaim it, it's yours to keep. So, it ended well.
wow. Would you mind telling us what makes someone eligible to file for, say, Chapter 7 bankruptcy?
It's a question of tolerance. I mean, creditors, the collection process, some people don't give a shit. And some people can't stand the phone calls, the ones who put their heads in the sand. And it's a matter of, once we get retained, that pressure, though it's not the way it used to be. It was creditors don't even call anymore. But, the pressure, once I'm retained, they refer the creditors to me. But, if they can cope with the calls, if they don't mind the lawsuits, the collection process itself can take between the time a creditor decides to send it to a collection agency and the time the creditor decides to send it to an attorney. That could be 2 years. And then by the time they file a lawsuit against you and get a judgment, that could be a year and a half. And then what happens when they get a judgment? Well, sheriff comes to your house with the judgment. In the perfect world, you say, hey, let me get my checkbook. How much do I owe you? And you write them a check. Well, being from Brooklyn and an inveterate cynic, there's no such thing as a perfect world. So what happens is now in Massachusetts and other states have the same process. It's sort of an antiquated, like debtor's court. They summons you to appear before a judge to inquire about your ability to repay. From a bankruptcy point of view, if a client goes there and says, Judge, I've retained an attorney to file a bankruptcy, the judge will say, see you later, come back in 6 months or a year, we'll see if you filed. But clients being clients, what happens when they don't show up at that hearing? The court will and does issue a capias for their arrest. And the next thing you know, they're tooling down the Mass Pike and they get pulled over for speeding. And the trooper takes them into the barracks because, whoa, Peabody District Court, we have a capias for your arrest. So, but even that, which is, from my perspective, the only thing I really warn people about if they have pending litigation that they should pay attention to, that takes place so far down the road that it's a question of what they can cope with. Like I tell them, they can only nudge you. It's a question of how much nudging you can take. My mother tried a lifetime. She never succeeded.
What differences would there be then in terms of eligibility between Chapter 7 and Chapter 13?
Well, it strictly comes down to the factors I mentioned before. If your income is above there's a third factor that I've encountered recently. I'll get to that in a second. But if your income is above the means, then you have to do the complete means test. And what comes out at the end is what you'd wind up paying your creditors over 60 months. So if it's $100, it would be $6,000 as a plan. The other reason for the Chapter 13 is because, like I said, mortgage arrears. I've had people, I mentioned 2 years before, but that sometimes it's even more than that. It's a matter of cash flow. But again, it stops the foreclosure, which usually is what results in the filing. And then you have to be able to pay that arrears. I just filed a case. The poor guy, his wife passed away unexpectedly, and he has 5 kids. And we filed the Chapter 13. He's not a Chapter 13 candidate income-wise. We filed it to stop his mortgage payments. And fortunately, he should be able to make both payments, the current ones and the arrears payments out over, because it's like $60,000 in arrears over the 5 years. But, if you can't, it's tough. The third thing I've encountered recently, much like I've been doing this long enough to file bankruptcies for the same person 4 times, is some people, because you can only file another Chapter 7 after 8 years from getting a discharge. And I've had a number of people who are now inundated with debt that are contemplating filing a Chapter 13 because they have to wait 3 or 4 years to be able to file a Chapter 7 again. I've told them that from an attorney's point of view, you'd be surprised how quickly 3 or 4 years passes. But, a few of them are filing Chapter 13s to deal with it because they're not eligible to get a discharge in 7.
It sounds to be an edge case that I would not want to end up being in. I'm interested in knowing what other common misconceptions or myths about bankruptcy do you often encounter, and what do you do to address them?
My standard spiel is, there's no guarantees. I'll say, I can tell you the sun is going to come up tomorrow, but I'm not necessarily going to guarantee it. I've never seen, people wonder if the trustees are going to come to their house if somebody is going to do this, that, for their $65, like I said, they're not coming out to your house. They're not schlepping anything because we have an appraisal. I got a lot of dreck in my office here. You know, I spoke about my pipes, but they mean something to me. Value-wise, what value do they have? And unless people have a Picasso hanging up on the wall, which nobody, you know, my mother used to go to yard sales, and I said, Mom, when you buy the card-playing dogs with the Picasso, we'll talk. None of them have. You know, most of the concerns are misplaced because, you know, they find, you know, at the 341 meeting, we usually schmooze with the trustee and, you know, they ask their questions. It's not particularly intimidating, the questions they ask. You know, they've asked the same questions that you've already answered in the petition, but since attorneys are redundant, you know, that's what we do, put it on the record. You've already filed it under the pains and penalties of perjury. But the most difficult thing is to get around a friend told them, you know, or somebody said, or they did some research. You know, because much like, you know, I can research doing heart surgery and, you know, maybe I'll meet you in the back alley and I'll try it. But, you know, it's not something I'm going to try. I mean, and, you know, unfortunately, lots of people, you know, I call us MOBs, for member of the bar, us MOBs, you know, show me your Google law degree. It has nothing to do with reality. You know, it's just the way it is.
How does filing for bankruptcy affect an individual's credit score or a business's financial standing? And what happens after that? How do you rebuild?
Well, you know, getting back to the businesses, what I do for businesses, you know, because, you know, if you're talking about a business filing a Chapter 7, you know, for me, the only reason I would file one would either be, you know, I have a case now I'm going to be filing because they're involved in some litigation. That the only way it goes away is through the bankruptcy filing. But generally what I do for closely held corporations or LLCs is in Massachusetts what are called assignments for the benefit of creditors. It's a voluntary liquidation of a business. The reason I suggest that over Chapter 7s is that the same thing happens to a corporation or an LLC. Their assets get liquidated, they don't get a discharge, and that's it. And in the assignment, we, you know, liquidate the assets, we send a notice to the creditors and solicit their assents. And that's what happens. Nothing different with respect to a Chapter 7. The company just becomes like the legal fiction it is. You know, I just, under an assignment, these guys had created this fascinating software. If you were looking for an apartment in Boston, you could look at all the apartments and you could applications and brokers could do it. But of course they couldn't penetrate the market. And yesterday we auctioned the stuff off for about $38,000. Wasn't bad, but you know, that would be the same thing that would happen in a Chapter 7. And I said, why put the individual through the 341 meeting when we do an assignment? You come to my office, we sign a few pieces of paper. The person I use to be the assignee is a good buddy of mine, an aging deadhead and attorney. We send notices out, and you know, we don't make that big a megillah about it. The only for my a company has to do is if they have to file a Chapter 11. You know, the IRS is going to seize the assets. Secured creditor is going to seize the assets. You know, the assignment for the benefit of creditor doesn't stop that. You have to file a Chapter 11 if you want to hope to do something about it. But even those, you know, 90% of those are unsuccessful.
Barry, thank you again for a great conversation. The things that we've learned about bankruptcy, the what to do's, maybe what not to do's in a lot of ways.
Well, I tell you, I'll leave you with one. It's like the guy who once came in to see me and said, "Do I have to tell you about the property I own in Maine?" And my response was, "Schmuck, now you do."
Barry, thank you again. This has been Bankruptcy Through the Looking Glass with Barry Levine. Again, I'm Sam Henninger. Please like and subscribe to get more conversations around bankruptcy and more of Barry Levine. Welcome to Bankruptcy Through the Looking Glass with Barry Levine.